I'm attorney David Rodriguez with immigration-consultation.lawyer, and we're checking out some important websites for immigration. Today, we're taking a look at the USCIS page, options for non-immigrant workers following termination of employment. Now, I have a lot of consultations about this topic, especially people on H-1Bs, whether they're fired or nervous about potentially losing their job. And if you take a look, what's weird about this page is it's archived content. So some of the info is out of date, but may still be useful. And they archived the page, so it may not be easy to find for people trying to look this stuff up. But as of right now, May 2026, this is the proper information from the government about your options when you're laid off or lose your job. Now, what happens is when you lose your job, you get a 60-day grace period. Some people may wrongly assume that they have to leave, but they have this 60-day grace period. And in this 60-day grace period, you basically have these four options. There's bullet points here. You can file to change your non-immigrant status. You can file for an adjustment of status, which we won't really get into because there's been some changes with the adjustment of status and it's not fully fleshed out yet. You can file for a compelling circumstances EAD, which really isn't going to help you with your immigrant status or remaining in the U.S. We'll check that out in a little bit. Or you could be the beneficiary of a non-frivolous petition to change employer, basically getting a new job. Now, if one of these four things happens within this grace period, you're going to be in what's called a period of authorized stay. And that basically means you're allowed to remain in the U.S. while an application or a petition is pending with the government. So if you get it in on time within the grace period, then you could remain in the U.S. while they're processing the paperwork. So let's take a look at these questions and answers and try to figure out all these options. First, let's look at the grace period. You have a maximum of a 60-day grace period, and this is the list of all the employment visas where you get this grace period. F1s also get a grace period, but that's a student visa, so that's not why it's not in the list. But you get 60 consecutive calendar days. So holidays not included, weekends, no, it's 60 straight days where you have this grace period. And they say, well, why is it important? It's important to give you more time to stay in the U.S. to figure something out. And one of the big questions is, when does the grace period start? The grace period starts when typically your last salary or wage is paid. So they're going to go off of your last check stub. Now, I was laid off today, but then I worked an extra few days and have some holiday days. You really need to sort that out because the government's really going to look at the last paycheck, and that's when they're going to determine when the 60-day grace period begins. And the next question is, how do you apply for the grace period? Well, there's no real application for the grace period. It just kind of starts on your last day of work, the last day you were paid. Now, when you do file something, you should put in a cover letter that you're in your grace period and requesting that USCIS favorably exercise their discretion to grant that grace period if something is filed within that 60 days. So you have to show proof, and the proof is going to be basically the check stub. And that's what they're going to go off of. If it's a little bit different, you're going to have to write up an explanation as why that check stub is not indicative of the grace period and why it should start from a different date. Now, usually that means that someone wants it to be later than the check stub date because they still want to be in that 60-day grace period. So you really have to be careful and really check the calendar and make sure you get something in. Now, most people are wanting to get another job within the grace period and not change their status to a B2 or something like that, but we'll review that in a moment. The grace period applies even if you quit. So you don't have to be fired. You can quit and have a grace period. And then how many times can you use the grace period? Basically only once per employer. So you're laid off, you're fired, you quit, you get a 60-day grace period. If you then get back on H-1B, for example, with a new employer and you're working for them and then get terminated down the road, then you may be eligible for another 60-day grace period, but usually only really have one grace period. Now, what is your status? Well, your status is you're continuing to maintain non-immigrant status during that grace period, which is good. You're still in your H-1B status, even though you were fired, let go, quit, whatever. That 60-day grace period is still in the H-1B or one of these other employment visas. Now, you can't work during the grace period. You're fired, you're trying to get another job. You can't work without employment authorization. Your authorization to work was with that employer. You don't work there anymore, so you can't work during that grace period. But what if the employer that you had rehires you during the grace period? That's fine. Then you just, like nothing ever happened, you're back on track. If you're rehired, uh, now it's got to be the same job. It can't be a changed position, because your employer will have to amend or file a new petition because there may be a material change in your employment, and your employment is based on a specific job title. So it needs to be the same job, or the employer may have to file an amended or new petition. If it's the same employer, you can start working for them right away if they rehire you during the grace period. Traveling, can't really do it on the grace period. If you leave the US, you're done. So even if you have 30 days left on the grace period, you leave, you can't come back and get the remaining days. You need to get another visa at that point. Now, if you're overseas and you get fired while you're outside of the US, you can't then fly in and say, hey, I got a grace period. They're not going to let you in, and you have to get another visa. Now, if your spouse is on an EAD, like an H4, although you can't work, your spouse can still work during the grace period. So they have 60 days to kind of um, quit their job or cross their fingers and hope they maintain the job, that you get another H-1B within that grace period. And for this OPT, that's a separate topic. We're not really going to go into that. That's an F1 visa. There's a 90-day aggregate of unemployment that you can have. It mentions it, but that's more of a student visa OPT breakdown video. So that's essentially the grace period. You have 60 days. It starts on your last pay date on your check stub. You can't work during the grace period. Uh, you only really get one per job. Uh, your status is maintaining the same status as basically the H-1B for that extra 60 days. You can't work. If you're rehired with the same job, you could go back like nothing ever happened within that grace period. You can't travel. You can't come back if you're terminated. Your spouse still can work on the EAD, on the H4, during that grace period. If their spouse EAD is incident to your status. So that's the grace period. You get 60 days. Now here's the next section, the portability of employer petitions. There's two kinds of porting. You can't work, right? We talked about that. But if a new employer files an I-129 within the grace period and you get the receipt notice, you can start working for them right away without getting approved yet. You get the new receipt notice within the grace period. So you don't have a lot of time. You have 2 months, you have 60 days. You need to get a new job right away, and have that employer file for you, and you could start working even without having approval. The second porting has to deal with an adjustment of status, which is a little bit different topic. Your I-45 has to be pending for at least 6 months, 180 days with an approved I-140. That is to get an immigrant visa on like an EB2, EB3, EB1 even, something like that. Okay, so can I port to a new H-1B employer during the grace period? Yeah, you can. They can file an I-129 within the grace period. You could start working for them right away. It's a non-frivolous H-1B petition with a request to amend or extend your H-1B status. So that's the best thing that could happen, is getting that new job within that 2 months. And also have to keep in mind that the employer still needs to file a labor condition application, LCA. So that needs to get in there pretty quick for them to then file an I-129. So you don't have a lot of time to do that. So if you don't have a lot of time to do that and that does not happen, you don't get a new job within the grace period and you're getting close to the end, then you may want to consider changing your status. Most people file the change to a B2, B1, B2, give them a little bit of extra time, or F1, go back to school. But you got to make sure that I-539, the application to change your non-immigrant status, is filed within the grace period. And when you submit that, if you submit that online, you'll get a receipt notice right away. And then what happens is the I-539 is filed, your grace period ends, you're no longer in status, and you begin on this period of authorized stay, which is not a status, but you're not accruing unlawful presence, all right? You will not accrue unlawful presence while the application remains pending, even after the maximum 60-day grace period has elapsed. So you got to get it in there within the grace period, and then you could chill and wait. And that gives you more time to find a new job. But the difference is, unlike within the grace period, you can't start working right away. You need to wait for that to be approved. So changing, and you could even change to an H4 if your spouse has an H1B and you have an H1B, you lose your job, you can go on an H4 or an L2. You could change to an F1 or a B2. And then if you're on that, you can't work. So your grace period is ending. You're filing for the B2. You're in a period of authorized stay. You may get an extra 6 months. It may just stay pending for a couple months and then it gets denied. But that gives you extra time. But you can't be working during that process. So if you're seeking a new employer, if you're seeking a new employer during the period of authorized stay, you can't work until the I-129 is approved, and we're going to get that. Can you expedite it? Yeah, but not really. But here's the big one. While my I-539 is pending, right, to B1, B2, will that be prioritized if I find a new employer? So the grace period's expiring, you file to change your status to a B2, and then you find another job. Now your employer is going to file an I-129, but you have a pending I-539. Well, what happens? Well, they're going to issue concurrent decisions, which means they'll probably approve the I-129, so you could get back on H-1B and deny the change of status of the B2, which is fine. But with that scenario, your employer is also going to have to submit for premium processing, and then you can't work during this time frame until it's approved. So that's where the premium processing comes in. Unlike when it's filed within the grace period and you can start working right away as soon as you get the receipt notice. Here, when you're filing to change your status to a B1, B2 and the I-539 is pending, the employer will need to do a premium processing along with that I-129. And this question here, can I file a change of status to B1, B2 if I have a pending or approved I-140? They say yes. And the reason this is a question is because a B1, B2 is a non-immigrant visa, non-immigrant intent, where an I-140 is for an immigrant visa with immigrant intent. There's kind of a conflict of intents right there with your mental state. But oftentimes you can't adjust status or get consular processing for maybe years down the road. So you may have immigrant desire, not immigrant intent. Anyway, nevertheless, they say, yeah, you can do it. And can you look for a job? Well, that's the purpose of filing for the B2 is to look for a new job because you want to work. And the answer here is yes. But there must be approval first while you're in B1, B2 status or it's pending. So here, a petition to change status from B1, B2 to an employment authorized status must be approved and the new status must take effect. So you'll have on the approval notice a new I-94. And then if it's denied, yeah, also if the change of status request is denied or a petition for new employment requested consular, if the new employment requested consular or port of entry notification, then you must leave and get the visa overseas. Um, if your new employer's petition is denied, can you file an appeal or a motion? No, because you're not the petitioner. It's the employer who's going to be the one who's going to appeal. And separately, if you're filing a request to change your status or an extension, it may not be appealed. Uh, but the employer may appeal the I-129. They could also file a motion to reopen, and that form is the I-290B. It's the same form for an appeal or motion to reopen or reconsider. Um, Now, if that during that time you're accruing unlawful presence because you'll be out of status. It's denied, and it will continue to accrue unless the petition or application is approved. Then you will not have accrued unlawful presence. So you're kind of crossing your fingers there, hoping it gets approved, um, in order to not then accrue too much unlawful presence. Because if you have 6 months or more, you have a 3-year ban. A year or more, you have a 10-year ban. Let's check out this adjustment of status section. It's not much. And with adjustment of status, it's kind of in flux right now, May 2026. The administration has put out something where they're not going to do adjustments of status anymore, but we still need to see how that plays out. Let's check out this compelling circumstances EAD. It's a discretionary stopgap measure to assist individuals who are on the path to lawful permanent resident status by preventing the need to abruptly leave the U.S. It allows you to work, but it doesn't give you any status. You will be in a period of authorized stay without accruing a lawful presence while the EAD is valid, but you're out of status. So even if you get another job while you're on the compelling circumstances EAD, your grace period has expired, your change of status to B2 has expired or never happened, you can't go back to a non-immigrant visa and remain in the U.S. with that compelling circumstances EAD. Um, so it's not going to help you stay and adjust status in the U.S. So here it says, what is my immigration status and work authorization if I'm within the grace period while a compelling circumstances EAD is pending? Well, you're maintaining your status within the grace period. And if you file the compelling circumstances EAD, you will not accrue unlawful presence. But you can't work until that compelling circumstances EAD is approved. So, and then even if it is approved, you're in a period of authorized stay. You're not in a non-immigrant status. You have to keep the chain of non-immigrant status moving in order to go from non-immigrant to non-immigrant. So if you're going to go back to H-1B and you're on a compelling circumstances EAD, you're going to have to do consular processing. If you have a change of status pending while you have a compelling approved EAD, here it is. If the compelling circumstances EAD is approved, you're authorized for employment based on compelling circumstances. But if your I-94 is expired, you'll not be in non-immigrant status. You'll be in this period of authorized stay, this pending non-status validity period. And you can work, but you're no longer maintaining non-immigrant status, so you'll not be eligible to change your status in the U.S. You can't go from a compelling circumstances EAD back to an H-1B. You'd have to do that through consular processing. Expediting, yeah, you could try to expedite it, but that's a separate video. Yeah, you can't really file I-45 either. If you're on a compelling circumstances EAD, because in order to be eligible to adjust your status, you need to be in a status, and you're not in a status on the compelling circumstances EAD. So you generally would not be eligible to file an I-45, notwithstanding this whole new administration thing, May 2026, with the not being able to do adjustments anyway. We're just going off of the old standard. Um, Instead, you need to go through the NVC and complete consular processing. So the compelling circumstances EAD doesn't really help you out. Um, Once again, new employer files for your I-129 while you're on the compelling circumstances EAD. You're going to have to go through consular processing to complete that process. You can't go from not in a status to in a status in the U.S. Uh, you would not be granted a change of a status or extension of stay. You would need to apply outside the U.S. And yes, your spouses and children are eligible for the. So this compelling circumstances EAD is kind of like a last resort. It's not going to help you stay in the U.S. or change status or adjust status in the future. It's a stopgap measure for compelling circumstances, and proving that the circumstances are compelling are pretty hardcore. It's not just, hey, I need a job to feed my family. It's got to be a higher level than that. So when you're filing for that, you have to include a lot of evidence to show that your circumstance is compelling beyond the normal scenario of not having a job, because that's why people change to a B2 and they search for another H1B and they try to maintain the non-immigrant status to stay in the US. And when all else fails, then you could try for this compelling circumstances EAD, but it's not really going to help you out. Expediting, um, I've dodged that a couple times already. It's not really going to happen. There's ways to do it. How to make an expedite request is a separate video. And then if all else fails and you want to be eligible for a visa in the future, you're going to have to leave the US. You have a 60-day grace period. Maybe you could file to change your status to a B2. This is the normal process of what I communicate with people on my consultations. First step is try to get a new job right away, and get a new H1B and keep it moving and get that I-129 in during the grace period. That's great. Second is file to change your status to a B1, B2, or maybe F1, go back to school, give you a little bit of extra time. Uh, Even if it's denied or they're on the denial tip, the time that it's pending is still extra time to potentially get that new job. And if that fails or it's approved and you still don't get that new job and they don't file the I-129 with premium processing, you're going to have to leave the country and get another visa and come back to the US on consular processing. So these are your options. Let's go back up to the top. If your employment is terminated, you have a grace period, 60 days. During that time, you can change your non-immigrant status. You can file to adjust status. And if you use your EAD based on an I-485, even if you have an H-1B and you're working, you then lose your status. If you leave and come back on the advanced parole and not the visa, then you lose your H-1B status. You're then just living on a pending I-485, and you could work wherever you want to work. With that EAD, you're not beholden to the H-1B, but are you going to get approved when you have that adjustment of status interview, and that employer is no longer hiring you or intending to hire you? I don't know. So you're putting all your eggs in that one basket for the adjustment of status. That's why a lot of people want to maintain their non-immigrant status, so they have options. You can file for this compelling circumstances EAD, but it doesn't it doesn't help you remain in the country. That's a last ditch effort. And you could be the beneficiary of a non-frivolous petition to change it. It's basically getting a new job. So you can change your status. If you're eligible, you can potentially adjust your status. You can file the compelling circumstances EAD, or you could have a new employer file a non-frivolous petition. They put that non-frivolous petition in there, so it's like, kind of like a real one. You don't want to get dinged with misrepresentation or fraud. So that's a review of this important page, options for non-immigrant workers following termination of employment. I hope that helps you guys out. Just keep in mind that this page is archived. It's still kind of up to date, currently they haven't changed it to something else. This is what I show people to advise them of their options. But if that does change and get updated, well, please be aware of that beforehand. And then secondarily, I will try to put a video out about those changes. But continuing the review of important government websites, I personally like to use the government sites when I advise uh, clients because that's the legit information. So I just go off of what the government says and give you your options of what to do, and I'll be ready to do it for you. So check me out on immigrationconsultation.lawyer, or you can also check me out on Lawfully, which is a good app to track your case. And they also have a section for consulting with attorneys. I'm one of the attorneys on there. I'm on my way up to 1,000 5-star reviews. So it's very convenient to use. I do take clients as well. We can discuss that in a consultation. But once again, glad we could review this site. It's very important. It's happening a lot these days. And check that out yourself for review. And look forward to going over some other important sites in the near future. Thank you.